Start. Applicants Jayantu Lal, Rakesh Kumar, Sanjay and Pradeep have preferred this criminal revision against the order dated 20.8.2013 passed by the first additional sessions judge Jaunpur in sessions trial number 348 of 2012 in bracket state of Jayantu Lal and another bracket out arising out of case crime number C 389-A under sections 419, 420, 467, 468, 471, 120B, 195 and 384 of the Indian Penal Code in bracket in short IPC bracket out, Police Station Line Bazar, District Jaunpur, whereby an application under section 245 in bracket 2 of the Code of Criminal Procedure in bracket in short CRPC bracket out filed by the applicants in bracket accused persons bracket out has been dismissed by the first additional sessions judge Jaunpur full stop para. It appears that the parties have been litigating for quite some time, and during the course of this litigation, one Srimati Asharfi Devi, herein opposite party number 2 oblique complainant, moved an application under section 156 in bracket 3 CRPC against all the 4 persons named here and above, alleging that they have forged some documents and thereafter filed those documents before the Chief Judicial Magistrate, Jaunpur, full stop. They wanted to get the complainant Srimati Asharfi Devi convicted in serious offences, full stop. An affidavit in the name of one Badlu was also forged, full stop. This application under section 156 in bracket 3 CRPC was accepted by the learned Chief Judicial Magistrate Jaunpur and on 12.7.2007 full stop. He directed the police to register and investigate the matter, full stop. The case was registered as case crime number C389A of 2007 under sections 419, 420, 467, 469, 471, 474, 120B and 195 IPC, full stop. Thereafter, the police submitted the charge sheet on 22.10.2007 against all the 4 revisionists, namely Jayantu Lal, Rakesh Kumar, Sanjay and Pradeep under the aforesaid sections, full stop. The matter went up to the learned first additional sessions judge, Jaunpur as offence under section 195 IPC is tribal by the Court of Sessions, full stop. Section 195 IPC stands for fabricating false evidence with intent to cause or knowing it to be likely that he will thereby cause any person to be convicted of an offence which is punishable for imprisonment for life or imprisonment for a term of 7 years or upwards, full stop. Para. During the pendency of this trial before the learned sessions judge, the revisionists moved an application under section 245 in bracket 2 CRPC for discharge by denouncing of allegations of complainant Srimati Asharfi Devi and also on the ground that the prosecution of the offence under section 195 IPC is barred under section 195 CRPC, full stop. Application under section 245 in bracket 2 CRPC was dismissed wide impugned order dated 20.8.2013, full stop. This order is under challenge before this court in revisional jurisdiction, full stop. Para. Heard, Shri J.J. Munir, comma, Learned Counsel for the Revisionists, Shri V.K. Baranwal, Learned Counsel for Private, Respondent number 2, comma, Learned AGA for the State, full stop, para. In exercise of revisional jurisdiction, it is beyond power of revisional jurisdiction to reappreciate the evidence, full stop. Appraisal of evidence is not permissible in revision unless some glaring mistake is shown which establishes that injustice has been done, full stop. The court can only interfere if the impugned order is not in conformity with law or suffers from any material illegality, irregularity, perversity and jurisdictional error, full stop. The superior court cannot interfere with order of the lower court merely because it holds different opinion from that of the lower court, full stop. Thus, revisional court has to navigate within the parameters laid down by section 397 CRPC for exercise of this jurisdiction, full stop. Para. This court also cannot adjudicate the validity and veracity of allegations of either party at this stage, but the fact remains that the complainant has leveled allegations regarding certain papers which have allegedly been fabricated or forged outside the court and thereafter used in the court proceedings in order to procure conviction of the complainant, full stop. One affidavit prepared in the name of Badlu, is stated to have been disowned by Badlu himself, full stop. In any case, the entire case was investigated by the police and the investigating officer found enough evidence to file charge sheet against all the aforementioned 4 revisionists under the aforesaid sections, full stop. Truthfulness and veracity of this evidence cannot be adjudicated at this stage in the revisional jurisdiction, full stop, para. Learned Counsel for the Revisionists has also raised a legal question as well, full stop. He has submitted that a bar under section 195 CRPC is applicable in the instant case, as the prosecution has alleged that certain papers were forged and fabricated outside the court and thereafter used in the court proceedings, full stop. He submits that the inquiry under section 340 CRPC should have been conducted and thereafter the court should have filed a complaint instead of private party, full stop. He has submitted that in view of bar under section 195 CRPC, the proceedings of the case are liable to be quashed, full stop. For deciding this issue, it would be appropriate to extract material portions of section 195 CRPC, which is herein below been extracted, para. Prosecution for contempt of lawful authority of public servants, for offences against public justice and for offences relating to documents given in evidence, full stop, para. Second, of any offence described in section 473 or punishable under section 471, section 475 or section 476 of the said code, which such offence is alleged to have been committed in respect of a document produced or given in evidence in a proceeding in any court, or third, except on the complaint in writing or that court or by such officer of the court as that court may authorize in writing in this behalf, or of some other court to which that court is subordinate, full stop, para. The Learned Counsel for the Revisionists has submitted that the fabricated documents were produced in the court proceedings, therefore, the bar under section 195 CRPC is applicable, full stop. But it is evident that this bar is only applicable if forgery and fabrication has been done in connection of documents which were in the custody of the court, full stop. If the forgery regarding such documents has been done, their prosecution can be initiated only by the court concerned through the complaint made in this regard, where forgery was done outside the court or prior to its introduction in the court's proceedings. The bar of section 195 CRPC would not be applicable, full stop. In this connection, the judgment of Apex Court in the case of Sachidanand Singh versus State of Bihar in bracket law SC 1998 to 1994 AD in bracket SC 1998 1534 can be referred with profit para. The sequitur of the above discussion is that the bar contained in section 195 in bracket 1 in bracket B second of the code is not applicable to case where forgery of the document was committed before the document was produced in a court, full stop. Accordingly, we dismiss this appeal, full stop. Para. Coming back to the facts of the case, complaint of Srimati Asharfi Devi indicates that the documents were forged and fabricated prior to the court proceedings, full stop, over.